A rule dictating who's allowed to use which restrooms in schools has now sparked a lawsuit against the state of South Carolina and one of its school districts.
The lead plaintiff is a teenager asking to act on behalf of thousands of transgender students in South Carolina.
State House reporter Mary Green has the details.
This lawsuit focuses on a temporary law in the current state budget called a proviso. The people who are challenging it claim they're now facing, quote, grave violations of their civil and constitutional rights because of it.
This lawsuit seeks to block the state and its schools from enforcing the rule. It requires people, including students, use school restrooms and locker rooms based on their biological sex at birth. Schools that violate the law risk losing a quarter of their state funding.
Stipulates in school settings that a boy will use the boys' bathroom, the boys' locker room, the boys' changing room. A girl will use the girls' bathroom, the girls' locker room, the girls' changing room.
The lead plaintiff is a 13-year-old transgender boy enrolled in the Berkeley County School District, which is named as one of the defendants, along with its superintendent, the South Carolina Department of Education, State Superintendent Ellen Weaver, and the state of South Carolina. The lawsuit refers to the student by the pseudonym John Doe and says he had been using the boys' restroom at his middle school and that no students raised objections. But it claims school leaders told Doe that because of this new law, he would either have to use the girls' restroom or the single-stall restroom in the nurse's office, later suspending him and threatening expulsion for using the boys' restroom as Doe had been before. The lawsuit says Doe later faced harassment from other students and moved to online classes.
They've created a space for trans students that's unsafe, that's not productive. It's not creating an environment where students can just go and learn and be with their friends and be themselves. And that's not fair. The
North Charleston-based LGBTQ advocacy organization Alliance for Full Acceptance is also a plaintiff in the lawsuit. It comes 4 years after the U.S. Fourth Circuit Court of Appeals struck down a similar law in Virginia, in a case the U.S. Supreme Court ultimately declined to take up.
When this budget proviso was passed, it was a waste of time, waste of resources, because this has already been decided. It's unconstitutional.
This lawsuit has been filed in federal court in Charleston, alleging the proviso violates the Equal Protection Clause in the U.S. Constitution, as well as federal Title IX law. Reporting from the State House, I'm Mary Green.
As of this evening, the state has not yet filed its response to the lawsuit in court. The South Carolina Department of Education declined to comment, citing pending litigation, while the Berkeley County School District did not respond to our request for comment.